the EU law, and that is unlikely to change. The freedom of establishment set out in Article 52 of the Treaty on the Functioning of the European Union ensures the recognition throughout the EU of a company incorporated in one member state. Therefore, by virtue of this treaty, company law throughout the EU member states is, so to speak, to a certain extent, harmonized. However, we have to keep in mind that as of the withdrawal date, companies incorporated in the UK will be considered as third country companies and therefore will not be automatically recognized under this mentioned Article 52, which I have just mentioned. And also it is important to note that we have a lot of UK companies acting as shareholders on Maltese registered companies, and needless to say, these will be effective as you will see throughout this presentation. The UK companies with main centre of operations in another member state are also considering moving. So next slide. Directive 2017-1132 of the European Parliament establishes the foundations for the harmonization of certain aspects of company law and creates the conditions to effectively promote the freedom of establishment. The directive addresses the incorporation of limited liability companies and the introduction of centralized companies registered and set the capital requirement of public companies. That is, I'm saying all this in order to introduce you as to why the Brexit is going to affect us, Maltese agency. All these conditions will, of course, no longer apply to UK registered companies, and therefore it is important that all the stakeholders, including the employee and any creditors and investors dealing with UK companies, to be aware of this situation, that, of course, the basis of the European company law will not be applicable to UK companies. When we come to cross-border mergers, the next slide, this is also dealt with the same mentioned directive, and the chapter specifically provides for procedural rules for cross-border mergers of limited liability companies. These rules apply to limited liability companies governed by national laws of different member states, which companies will be listed in Annex 1 of the mentioned directive. When we say cross-border mergers, we are referring when you have a company registered in Malta, which is going to merge with a member state company, and vice versa, having a member state company merging with a Maltese company registered in Malta. Therefore, once there is Brexit, this cross-border mergers will not be able to happen with the United Kingdom. Our next slide provides for the business registers interconnection system. As you might be aware, member states have business registers which are all connected via a European central platform through the business registers interconnection system, which we call BRIS. These are publicly accessible through the European e-Justice portal. This is a very useful register which links all EU company registers together. Needless to say, as of withdrawal date, information in the UK company register will no longer be exchanged via BRIS, therefore will not be accessible through the European e-Justice portal. As Article 36 and 37 of Directive 2017-1132 on business registers, member states have to provide certain information which is basic to the other member states. As I was saying, this information cannot be exchanged once the UK is no longer a member of the EU. However, having said all this, the UK is one of the countries that is famous for its transparency. And if one can see, if you go in the company's house, you will have all the information accessible to companies. Therefore, this will limitedly affect this information sharing in relation to BRIS, will limitedly affect us, the Maltese register, so to speak, because we'll not have direct interconnection between the registers. However, as regards third parties and for ourselves to verify, this will not be effective because we can still access information on UK companies, and therefore cross verification can also be done. Next slide, European companies, DSC. This is dealt with Council Regulation 2157 of 2001 on the statute for European companies. As of SCs can be created by companies or other legal bodies formed in an EU member state. Of course, the registered office needs to be in an EU member state. Of course, as of withdrawal date, SCs having the registered office in the United Kingdom can no longer enjoy the status of an SC. Therefore, the recognition of such companies by the other 27 member states would only be possible on the same basis as of a UK incorporated company. Therefore, will not have the SC mark as a company. According to Article 2 of this mentioned regulation, SCs can be created by companies or other legal bodies formed within the EU. Therefore, as at withdrawal date, the UK companies will not be able to enjoy such joining and participation in such SCs. Another form, and which is the next slide, another form relates to the European Economic Interest Grouping. This is like a consortium. It's not a company, however, it's more like a consortium. And this is dealt with Council Regulation number 2137/85. And EIGs can consist only of companies or other legal body corporates formed in an EU member state. Of course, with the registered office and central administration in the EU, or of natural persons carry out services in the EU. Therefore, UK legal bodies that are members of an EIG and were natural persons carrying out services only in the United Kingdom, these will cease to belong to an EIG as of withdrawal date, and therefore they need to make everything that is necessary in order to move their business outside the EU. Next slide, when we come specifically to UK involvements in Maltese companies, from research we have made, we have 2,253 active companies that have UK involvements within their structure. Therefore, for these companies, whenever someone is going to join a Maltese company having UK involvements, we would request a certified true copy of government-issued identification document and the bank reference. Since following the withdrawal of the UK, the British will also be considered as third country nationals. Therefore, nowadays, EU nationals enjoy a certain level of identification that, for example, we do not request bank references. We just request a copy of the identification cards, for example, or ID card or passport. In the case of the British, they would need to provide us with a copy of their passport together with a certified true copy of their passport and also the bank reference. In addition to that, further to the implementation of Regulation 2019/452, establishing a framework of screening of foreign direct investments into the EU, the Malta Business Registry has also started seeking the approval of the FDI unit by forwarding all relevant applications for company registration and share transfers relative to third parties and third country nationals to this unit. In this regard, any new company registered in Malta having British nationals or interests following the withdrawal of the UK from the EU will also be subject to FDI approval. The same is extended to existing companies that will have UK nationals joining their structures. These will also be subject to FDI. As a conclusion, redomiciliation of UK companies in Malta is still possible. Therefore, this can be a means whereby we can enhance our business and our link to the EU. We all know that we have strong links to the UK, and therefore redomiciliation of UK companies to Malta, they will still benefit by having a company registered in the EU that is using Malta. They will still have the benefits with other member states. Also, it is important to note that according to the National Risk Assessment carried out in 2018, UK nationals and companies are considered to be high risks in relation to AML and CFT. Perhaps this might be something new to the audience, because we always consider the UK as being, yes, they are British citizens, so it's fine. With regards to National Risk Assessment, UK citizens and corporate bodies are considered high risk, and this is because they have the large financial services system basically in London, and therefore that puts them to high risk. Therefore, being individuals having high risks, additional measures are adopted by the Register of Companies. That is, for example, we will conduct, our compliance unit and BR's compliance unit will conduct more on-site inspections on such structures involving UK nationals. Needless to say, the National Risk Assessment does not only identifies the UK as the jurisdiction which is high risk. The UK is one of them. Others are, for example, Italy, Russia, Turkey, Libya. So that's why on-site inspections are, in relation to the beneficial ownership information, are more targeted to these type of nationals. In addition to that, the Register of Beneficial Owners, which is a register that is accessible to the public, once the UK leaves the EU, then they still going to have the Register of Beneficial Owners, and that is accessible to the public without a fee. Basically, anyone can search the Register of Beneficial Owners of the UK Companies House. Therefore, we will still be able to use the Register of Beneficial Owners in order to make our verifications, both the MBR as an agency and also practitioners during their due diligence. So that was it from my side. If you have any questions, feel free to ask.
Thank you very much, Dr. Spiteri-Lucas. Seems we may have one question. Yes, we have a question which goes, why are there some companies registered in Gibraltar? Okay, I didn't quite catch that question. So if the person who asked it would like to rephrase it, of course.
Or to clarify.
Of course, or to clarify. In the meanwhile, however, Nico Shubaras, would you like to join us since you'll be taking the next one? Thank you very much.
Hi, thank you. Thank you, Timothy. Can you hear me?
Yes, I can hear you fine. We have another question from somebody for Geraldine. What is meant by UK involvements? Is this limited to directors of a Malta company, also with respect to shareholders of a Malta company?
So by UK involvements, we are referring both to shareholders and also to directors or beneficial owners. I think we have another question.
Yes. If there is a Maltese company owning a company registered in the UK, will there be any impact?
Yes, that company, so the scenario here is the Maltese company being a shareholder in a UK company. That would mean that that UK company is seen by both Malta and other member states as a third country company, basically. So will not be able to enjoy the structures that I have explained. For example, cannot be an SC, cannot take part in an AIG. And if that company comes to Malta as a shareholder, we still need the full due diligence as requested by other third country companies.
Okay. We have another. With regards to Maltese companies that use the UK holding scheme to have PECs and recognize the consolidation group, does anything change?
With regards to Maltese companies, I'm assuming that discussion is referring having a UK company as shareholder in a Maltese company. As such, only the supporting documentation that we are asking for would change. Otherwise, it would still be a Maltese company, and will enjoy, of course, all the benefits that the EU corporate law provides.
And a follow-up to a previous question regarding Maltese companies or shareholders registered in British dependent territories that are not part of the UK. Gibraltar, Jersey, Guernsey, Isle of Man, for example.
Those will still be considered, as we are considering now, as not part of the EU, basically. It's the same, that they will be in the same situation as is today.
Okay, thank you very much. If anyone has any further questions, they can ask them later as well. Let's hand over to Mr. Nico Shubaras for his presentation.
Thank you. Thank you, Timothy.
Thank you.
I will share my presentation. Can you see the presentation?
Yes, perfect.
So, during my session, I will briefly be tackling the direct and indirect tax issues arising as a result of Brexit. As you will note, my comments will be very, very general, because in order to go through all the specific cases and scenarios tackling the direct and indirect tax issues arising from Brexit, it would take a whole week. And obviously, we are, since Brexit hasn't even arrived, I mean, it's almost here, but we are still encountering new situations which we haven't even encountered. So I will try my best to go through this, and we can tackle any specific questions which you may have in the questions and answers after my presentation, or you can direct any specific queries by email. I will leave my email at the end of the presentation. So, brief introduction. So, for the purposes of my presentation, I will be assuming that there will not be any deal struck between the EU and the UK by the end of the transition period, being 31st December 2020. If there is no deal struck, the UK will automatically drop out of the EU's main trading arrangements, meaning that they will drop out of the single market and they will drop out of the customs union. What is the single market? The single market is sort of an agreement whereby member states share the same rules, for example, VAT rules, and other rules such as product quality rules and such other rules. As regards the customs union, this provides for an agreement whereby member states do not levy taxes on each other's goods. So upon Brexit, when the transition period ends, border checks and customs duties would be applied to imports of goods from the UK in terms of the rules of the WTO, the World Trade Organization. This is a particularly sensitive and topical issue when it comes to Northern Ireland. As you know, Northern Ireland, and not the Republic of Ireland, Northern Ireland is part of the UK. As part of the withdrawal agreement, a protocol was agreed to as part of this agreement, whereby Northern Ireland will remain part of the EU's VAT and customs VAT and customs area. Let's put it at that. So, on the other hand, the UK will decide what tariffs and checks to impose on goods coming from the EU. So let's go into some further detail. As regards VAT, up to now, I was getting a lot of queries from tax practitioners and businesses with respect to VAT, asking a lot of questions, which can be answered simply if you take a step back and you consider that upon the end of the transition period, the UK will simply be considered as a third country for VAT purposes. So it would be dealt with, transactions with the UK will be dealt with the same as you would deal with transactions you would deal today with other countries which are not part of the EU currently. So if you have a transaction involving services with the UK, that would be dealt with after the transition period, the same as if it were a transaction of services with any other third country, such as the US. So after the transition period, the UK will simply be a non-EU country. Any transactions with the UK will be dealt with as if they were coming from any other third country. If a deal were to be struck, it would be anyone's guess what the situation would be. So again, I cannot commit to whether a deal will be struck or not, but if a deal were to be struck, one would have to study the provisions of that deal or agreement in order to establish the impacts that would have on direct and indirect taxation, obviously. Again, I would like to draw attention to the protocol with Northern Ireland struck as part of the withdrawal agreement. This is particularly important when it comes to VAT. It is important to note that Northern Ireland will remain part of the UK VAT area, but the EU VAT rules concerning goods will continue to apply to Northern Ireland, but not services. It is important to note that this does not relate to services. So Ireland will remain sort of part of the EU, Northern Ireland will remain part of the EU for the purposes of goods. So the VAT implications as regards goods flowing to or coming from Northern Ireland will remain the same. Northern Ireland VAT numbers will have an XI prefix, as specified in the Council Directive recently implemented and as recently accepted by the Council of the European Union. I think it was last week, I believe, the Council Directive was finalized and approved by the Council, and it will soon be transposed into domestic legislation, whereby EU VAT rules will identify Northern Ireland VAT numbers with an XI prefix. Previously, those numbers the prefixes had a GB prefix, obviously, because Northern Ireland forms part of the UK. But now the GB prefix will not be identified as a valid VAT number for EU VAT purposes. Also, it is important to note, and it is very politically topical currently, that there should be controls between Northern Ireland and the UK with respect to goods, obviously, because since there should not be any controls between goods flowing from Northern Ireland to the EU, there should be controls, a hard sort of a border between the UK and Northern Ireland, because otherwise goods will flow into the European Union from the UK, import VAT-free, obviously. This is quite politically sensitive. This is being discussed. As regards customs, it's very similar to VAT. The UK will simply be treated as a third country. Customs regulations will start to apply upon the end of the transition period. Import or exports from and to the UK will have to be declared, as is the rules for imports and exports to other third countries, as it is currently. This also applies if the goods are transported through the EU. Northern Ireland will remain part of the customs territory of the UK, but EU customs rules concerning goods shall also apply in Northern Ireland, similar to what we discussed for VAT. As regards direct taxation, for individual tax programs which are provided for domestically, with respect to the Malta retirement program rules, these rules had to be amended in order to extend the program to third country nationals. This was particularly important for UK citizens who were beneficiaries under these retirement program rules, and who, due to changes brought about by Brexit, would otherwise have been unable to continue benefiting from these rules. As regards the residence program rules and the high net worth individual program rules, individuals benefiting from such rules were given the option to convert their status under the global residence program rules by the end of 2020. Direct taxes, as regards company taxes. It is important to bear in mind that for company tax purposes, direct tax purposes, the UK is considered a third country with effect from its withdrawal from the EU. Keep in mind that the withdrawal of the UK from the EU was technically on 1st February 2020. The end of the transition period is 31st December 2020, but effectively the UK left the EU on 1st February 2020. No effect, there has been no effect on the double taxation agreement agreed between Malta and the UK. So this double taxation agreement still applies currently, as it would have applied last year and will continue to apply. So that I would like to conclude my presentation. I mean, I know it was very general. I know that a lot of people probably have a lot of queries with respect to Brexit and a lot of specific cases which they would like to go over. I mean, it's impossible to go over in such a short period of time. But again, if you have any specific queries, please feel free to email me. I will try my best to reply to all your queries. And if you have anything you would like to discuss right now, please feel free. I think I saw some questions, right, Timothy?
Yes, we have a couple. So thank you very, very much for your time. I will read out the first one. So someone's asked how long the transition period is going to be.
The transition, so the UK effectively left the EU, as I said, on 1st February 2020. Then there is a transitional period up to 31st December 2020, during this transitional period, the UK would still have been deemed to be sort of part of the EU for customs purposes and VAT purposes. So once this transitional period ends, that is, it ends on 31st December 2020, the UK will be deemed to not be part of the EU for VAT and customs purposes also.
On to our next question. So someone's referring to the fact that the UK is being referred to as a high-risk area. So the question is, will it be considered the same way as Hong Kong and the British Virgin Islands, etc.? Or is it just an increase in document checks that we're going to be facing?
I think this is a question which Geraldine
Yes.
would be better and would be in a better position to answer. So feel free, Geraldine.
So can I have the question again, please?
No problem, no problem.
Because I'm not seeing it, to be honest.
No worries. So this is regarding the fact that the UK is going to be considered high risk.
No, it's popped up. Yes, okay. So, but will be considered. So I was referring to the national risk assessment that was conducted in Malta in 2018. Yes, Hong Kong, BVI, etc. are not high risk. They are of risk, but not the highest risk. If I'm not mistaken, the jurisdictions of the highest risk are UK, Italy, Russia, Libya, and Turkey. However, this can be accessible from the National Coordination Committee website if you are interested in seeing who have the highest risk in relation to AML CFT.
Thank you very much. All right. If there's no other questions, I'm going to pass on to my colleague, Mr. Leandro Borch, who's been our contact person at the ministry this entire time. And as I said in the beginning, thank you very much for all the support over the past weeks.
First of all, I apologize for running late. I was in another meeting. I couldn't get out. I didn't get to hear the two presentations. I got to hear Nico's presentation only, but I guess there were some questions before that that my colleagues addressed already. From my end, I wanted to conclude by saying this is the last webinar that we're organizing, but obviously it's not the last opportunity to get in touch. The Malta Chamber still have a contact desk and can pass on queries to our offices, and we can address them. Similarly, you have our contacts. Maybe Timothy can even make them available on the chat as well. If you need to contact us, don't worry. We're here to help you. I think that's all from my end.
All right, thank you very, very much, Mr. Borch. So for my part, once again, I'd like to thank the Ministry for all the support. Of course, let's see what actually happens now. We've got a change in presidency looming in the United States, which may have hopefully averted a hard Brexit due to the pressure on the British government, but we'll wait and see. Important thing is to be prepared for the worst. In the meanwhile, I'd also like to bring our attendees' attention to the fact that tomorrow we're going to have another event. This is, of course, not going to be about Brexit, but it's about cybersecurity. So during COVID, one of the unexpected side effects, you could say, is the great increase in cybercrime. So tomorrow, the Malta Chamber's got an event at noon about this. You can register on our website. And on the 15th of December, we have an event with Malta Enterprise where we will be talking about energy efficiency and the scheme which you can apply to for your business to become more energy efficient. So watch our website, our Twitter, Instagram, and Facebook for news and updates. And as Mr. Leandro Borch said, if there's anything you need, please do not hesitate to get in touch. Thank you, everybody.
If I may add one last word before we conclude.
Absolutely.
Please follow our page as well, because there are negotiations. The negotiations are still ongoing, and there might be some updates in the coming days. So we're at a very sensitive point at the moment. The negotiations have progressed, and technically there's good progress. We can say that almost 95% of the things that are being discussed at the moment, there's an agreement on, but there remains obviously very three main points of divergence, which are of course related to governance, level playing field, and another issue on fisheries. But as I told you earlier, I think there might be some updates in the coming weeks. Obviously, this is still a work in progress, and as you would appreciate, negotiations are very complicated at this point. We're nearing the end of the transition period, and obviously both sides are now trying to make their gains and concessions, and we're trying to strike a deal as early as possible before the end of the year. So please follow our webpage and our Facebook page. Follow the news, obviously. We might have some updates, and if things go well, we'll even update you on the new deal, maybe, and how best to prepare for that as well.
So in other words, you never know, we might have another session.
We might have.
So thank you very, very much. Thank you. And to the panelists once again, have a good afternoon. And if anybody needs anything, do not hesitate to get in touch. Ciao.